Hi guys, welcome back to my channel, and today we continue to talk about privacy laws, about every aspect of privacy law that your business and your all people within your company will need to be aware of. And the reason that I decided to talk about this topic today is that there's a lot of misunderstandings nowadays around the true applicability of California and privacy laws. And my purpose of this video is to delve deeper into this privacy law today. And after watching this video, I'm sure that you will be a bit more expert in this issue and will be able to define by yourself whether or not you'll need to comply with this law, and you will be sure more aware of it. Okay, let's talk a bit about history and start with it. In June of 2018, the Californian Consumer Privacy Act, known as CCPA, was passed, and actually it established a new system of privacy regulation that has never been seen before in the United States. The law requires companies to implement a range of privacy initiatives, from publishing an easily accessible privacy policy to allowing consumers, for example, to opt out of data collection practices. In November of 2020, Californians voters approved an amendment to this CCPA, known as CRPA actually, and it amended to CCPA slightly and added a new additional privacy protection to consumers, and this actually changes they became effective from January 2023. Okay, so who is affected by CCPA law? The CCPA's obligations apply to business, which is defined as for-profit entity. So it includes a range of variety of entities, from sole proprietorships, partnerships, limited liabilities companies, corporations. So actually a variety of all possible legal entities that make some profit, make some money. This business for sure will need to collect consumer protected personal information directly or, for example, on its behalf. And they'll need to determine the purposes, like a means of processing personal data of users. And these companies will also need to perform their business operations in California, and they will need to meet one of the criteria defined as this privacy law, which we'll talk later about. Exceptions. As any law of the world, the CCPA has its own exceptions, which you need to be aware of, because you will be able to assess whether or not you need to be a subject of this law or not. Yeah. So first of all, non-profit organizations and governmental agencies. The laws will apply only if a non-profit organization is acting in a commercial capacity, but generally they are exempt from this law. Another reason for exemptions: if your company or a business or maybe any other organizations, they collect no personal information are collected, so no personal information is involved. If we talk about publicly available information, in most cases, you will be exempt from this law, and it will not be a subject of this law. Personal information, as we mentioned, they doesn't include publicly available information, and it's understood reason because it can be easily accessed by any person in the internet, and the variety of organizations. If your company doesn't meet the threshold criteria of requirements of this law, of the CCPA, it will be also exempt from this law, and it will not need to apply its requirements. If, for example, no Californians residents involved in the processing or collection practices, the law will not apply to you as well. When other laws, some for example federal regulations apply, sometimes they do not. Have a priority, and they exempt you from this law or from some other law as well. So personal information. What is this actually? Personal information is information that identifies, relates to, describes, or is capable, for example, of being associated with, or it could reasonably be linked to directly or indirectly to a particular consumer or household. All this is a definition is given in CCPA. On this slide, you can see the variety, different examples of personal information that are protected actually by the CCPA, and all they relate to personal information. So as we have already defined, personal information does not include consumer information, that is de-identified or aggregate consumer information. Personal information also doesn't include publicly available information like this, for example, such property tax records, and aggregated data is also not considered personal information. Also, for example, health information that is protected by Health Insurance Portability Act and Accountability Act, or for example, about Californians' confidentiality of Medical Information Act, all these types of information, they will be also exempt from this law. So be aware of checking whether you're actually the subject of this law, because there is some exemptions, as you may see. Okay, so CCPA's obligations apply to a business which does business in California and collects personal data from Californians. And as we spoke about earlier today, if it also applies to a business that meets one of the following threshold criteria that you see right here. Actually, the classifications that you see right now on the slide, this is my personal classification. They do not titled in this way in the law. It's just easier to remember them, and I just depicted them in such way. So let's talk about each of them step by step. First criteria, financial criteria. The law defines the first criteria in the following way. The business that as of January 1st of the calendar year had annual gross revenues in excess of $25 million in the preceding calendar year. So here are two important aspects to consider and to remember. First of all, we talk about gross revenue, so we will not consider net income, and it's not taken into account. We talk only about gross revenue. And the second aspect to consider is that the financial data for the previous year are considered. So not for the current, not for the previous or predicted revenue, only for the previous year. Remember about this. Next criteria, numerical criteria. CCPA applies to an organization that alone or in combination, for example, annually buys, sells, or shares personal information of 100,000 person consumers or households or more. In combinations means that, for example, if you have other US subsidiaries, you will need to consider all of them together. So you'll need to make the following calculations to be assured that this law applied for you, for example, or doesn't apply. The numerical criteria with the CRPA adoption, I mean that's this part that amended the CPA, it remained almost the same criteria, but with a slight change. Businesses should comply with this law if they process personal data of more than 100,000 users instead of 50,000 as was in the CPPA. So this is like the main difference between these two laws. And in the next slides, we will talk about differences between the definition of selling and sharing, because there is a slight difference, and you will need to be aware of it to be sure that you have like an accurate interpretation of this. Okay, what's next? It's also really important to stop here and to clarify the differences between households and consumers, because in the law we have like separate definitions for these terms. So when we talk about a consumer, we mean a single natural person who is a Californian resident, as we have already defined, and it is an identified person, so including by unique identifiers. In other words, a Californian who we can easily identify through one or a range of personal data for different personal information, and we talk about them earlier, you remember. When we talk about households, we mean a group of people, a group of identified consumers who cohabitate with one another at the same residential address, and they for sure will need to share and use the same or common devices or services. So here are two important points to remember. The first one is that these people shall cohabitate, which means that they like share their premises where they live, and they will also for sure share their devices they use, mobile phones, their computers, laptops, etc. So these two important criteria. Next criteria, commercial one. This is actually the third criteria defined in the law. I call this a commercial one because it's outlined the purpose of business practice. And actually here is the purpose is that the business want to generate some revenues from selling or sharing personal information. So business does it for commercial or economic interest. CCPA also applies to organizations that derives 50% or more of their annual revenue from selling or sharing personal information. So let's see the difference between these two terms, because we spoke about them earlier today and we'll need to understand them. Selling or sell, the term is defined in CCPA, and it means selling, renting, releasing, disclosing, disseminating, making available information in any other possible way. by the business to a third party for monetary or other valuable consideration. So, and you see this phrase highlighted, for monetary and other valuable consideration. Remember this one, because this is like the main difference which identify and which delineate selling from sharing. Because when we talk about sharing, we will mean the same scope of actions with using information like renting, releasing, disclosing, making available, transferring, any other possible way, but like for like doing using all this information to a third party for cross-context behavioral advertising. So the next highlighted phrase that you see is for cross-context behavioral advertising. So actually this term cross-context behavioral advertising, it's also provided by CCPA, in CCPA defined, but it's commonly referred to like targeted advertising. It's like tracking of an individual's activities across websites, across platforms, applications, and a variety of other web resources, like in order to identify and present advertisements tailored to their specific behavior. And typically this involves using of third-party cookie tracking. Yeah, according to the amended CRPA, visitors who withdraw their consents to the sale or share of their personal information, they cannot be tracked for the purpose of targeted advertising. So that's why it's so important to understand the differences between these two terms, because you need to ensure that your company does not do this, yeah, or if it does, it should provide consumers with specific rights guaranteed by this law. Okay, and for like the final that I would like to summarize everything we spoke about today is that not all criteria of the CCPA law we talked about today need to be used simultaneously, right? Any of them alone is sufficient. To fall within the scope of the CPA or amended CPPA, the organization must meet at least one of the following criteria, of the following threshold. So either of this, like any of these options, if your company, if you define by yourself that any of these criteria applies to you, financial, numerical, or commercial, and you check to this information and you're ensure that it's in such way, you will need to follow the CCPA for sure. So remember about this, guys, and do not fall within the trap that like this law applies to you in all cases if you just do business if you just do business in California or collect Californians data from Californians. So thank you for your attention. Thank you for watching this video, guys. And as usual, I'm waiting for your comments, for your questions, and see you in the next videos. Bye.